So there's something for everyone here. There's definitely something for everyone here. So please buckle up. If you need some water, I have water beside me. Please feel free to grab a bottle of water, grab your favorite beverage. If it's a coffee, it's a cold or cozy morning in Lagos today. Well, afternoon now. So if you are in Lagos as well, please feel free to take that sip of coffee or tea to just warm you up a little bit more. So right now, I will be inviting on stage the MD PAC Registrars and Investor Services, Mr. Ifeanyi John, to take the welcome address. Mr. Ifeanyi, are you here with us? Are you good to go? Let me.
All right.
Hello, sir. Welcome.
Yeah, thank you, Ifeanyi. Just
yes,
like
sir.
you said, I'm equally excited to be here. So thank you. I want to say thank you and welcome to all of our panelists. And with special thanks to Mrs. Taiwo Akoni, the Chief Magistrate of the Ikeja Probate Registry. Thank you so much, Madam, for accepting our invitation. I also want to say a big thank you to the PAC team that have made this happen at the back end. And also, of course, to all our viewers out there that have logged in Nigeria and outside the country. Thank you so very much. We are delighted to have you on board. Why are we here? Just like Nipolo has said, the next 45 minutes to 1 hour is to, give a clarification what probate is and what the simple steps you need to actually, process your probate. Also, I want to, if you are here and you are currently undergoing a probate process or you're about to start one, it simply means that somebody have died or you have lost a loved one. We do sympathize with you, and we hope that you find this session useful. As we know that the probate process could be very frustrating sometimes and discouraging, to even continue. And so for us at PAC Registrars and Investor Services, when it comes to probate and transmission services, for us, our goal is to make sure that we make the bereaved family happy again, by taking them through the simple process and delivering on time. And so if you are here and you need our service, in any way, I will encourage you to contact us, as our partners and team of probate solicitors will be on hand to advise you, to guide you, and to support you through the process. Without taking much of our time, once again, I thank every one of you that have logged in from anywhere in the world, in Nigeria and anywhere in the world. Thank you for coming on board. We're excited to have you, and I look forward to an exciting time together. Sit back and enjoy this session. Back to you, Fifolowa. Thank you so much.
Thank you so much, Mr. Ifeanyi. That's a wonderful way to introduce the session. Thank you so much for those kind words. Yes. So I will go ahead to introduce our lovely panelists so that we can get into the discussion proper. So with us is the amiable, the distinguished Chief Magistrate Grade 1 with Lagos State Judiciary, Mrs. Taiwo Deborah Akoni. Please, a round of applause in the chat. Let me see the round of applause rolling in the chat. It's an awesome time to be here with you, ma'am. She obtained her Bachelor's of Law degree from the University of Ibadan in 1988. She thereafter enrolled at the Nigerian Law School and was called to Nigerian Bar in December of 1989. So she's been at this for a very long time. She obtained a master's degree from the University of Lagos in 2012. She was in private legal practice for many years in the law firms of Afolabi Adeniro & Co. and Ayinde Sani & Co. before joining the Lagos State Judiciary as a magistrate. She has risen through the ranks and now a chief magistrate. She has also attended several workshops, seminars, and trainings in the following areas of family law, judicial ethics, computer training acquisition, and so on. So please, a round of applause for Mrs. Taiwo Akoni in the chat. Let me see those emojis flooding in. It's an awesome time to have you here with us, ma'am. So I'll go ahead to introduce Mrs. Egbe Osikena. Mrs. Egbe Osikena holds the position of Head, Legal and Company Secretary at Pan-African Capital Group. Before her tenure at the group, she served as a partner at E&P Legal, also known as Esebo and partner situated in Ikoyi, Lagos, Nigeria. In this role, she led the Corporate, Commercial and Transaction Advisory Department. Egbe is an alumna of the University of Benin with additional qualifications, including an LLM in commercial law from the University of Cape Town, South Africa, and a Master's of Business Administration from Obafemi Awolowo University. Please note that, like I said, PAC session today. Her professional expertise encompasses corporate commercial transaction, advisory, M&A, debt recovery, intellectual property, and general civil litigation. Egbe's portfolio includes advising and representing diverse foreign and local clients in significant transactions, contracts, and disputes, both domestically and internationally. She holds membership with the Nigerian Bar Association, is a member of the Institute of Chartered Secretaries and Administrators of Nigeria. Her professional affiliations reflect her commitment to excellence and ongoing professional development in the legal and corporate governance spheres. So please, a round of applause once again for Mrs. Egbe. Thank you so much for joining us today, for letting us be in your presence, ma'am. Thank you. And I'll go ahead to introduce Mr. Yinka Adegbola. Hello, sir. He is the Managing Director of PAC Trustees Limited and has close to 2 decades of experience in legal advisory, company secretarial services, and trusteeship. In his role as Managing Director, Yinka articulates a vision for the firm's purpose and business strategy, leading the firm and its people, and helping to develop and foster a culture consistent with the firm's values. Prior to his current role, Yinka worked with institutions such as Sky Bank, now Polaris, Intercontinental Bank, Meristem, and Apple, where he pioneered the trust business of some of these institutions. Yinka has led trustees, transactions, and project initiatives across public, corporate, and private sectors in Nigeria. Yinka holds a Bachelor of Law and Masters of Law degree from Obafemi Awolowo University, Great Ife. He is a fellow of Institute of Pension Funds Managers of Nigeria and a member of several professional bodies. He has attended several trainings, both locally and internationally, and delivered papers on trusteeship. So please, a round of applause for Mr. Yinka Adegbola. It's an honor to have you here, sir. I'll go on to introduce Mr. Babatunde Oyeniyi. Mr. Babatunde Oyeniyi is an investment banker with 2 decades of experience within the capital markets. His experience cuts across finance, capital raising, relationship management, business development, product management, and business solutions. He holds an HND from Yaba College of Technology and an MBA from Ladoke Akintola University of Technology. He is also a member of the Nigerian Institute of Management, NIM, Institute of Chartered Secretaries and Administrators of Nigeria, the Institute of Chartered Accountants of Nigeria, and an associate member of the Institute of Capital Market Registrars. He has a lot of professional qualifications and certifications within these areas of expertise. Mr. Babatunde is currently the Divisional Head Business Solutions at PAC Registrars and Investor Services Limited. So definitely these are individuals with a huge portfolio. It is an awesome time to have them with us today. Please, a round of applause for all our panelists. The questions that we're going to be throwing at them, we trust that they're going to have the expertise, the knowledge, the ability and capacity to answer these questions as best as they can. So please feel free. If there are any questions they're like, I like this question, please remember that you can always submit them over in the Q&A so that we can have a brief Q&A session at the end of the at the end of the program. So thank you so much. Again, welcome to Succession 1.0. This is the first of many that we hope to start. So who is ready? Shall we begin? Please, whoever is handling the PAC registrar's account, kindly help to enable the chat so everyone else to be able to give in their input. I don't think it has been enabled for everyone to give their input. All right, thank you so much for that. So I think we can dive straight in. We're already into the time of the discussion. So I think I'll throw the first question at Mrs. Egbe. Yes, ma. So probate sounds intimidating. I mean, the first time I heard of probate, I was like, okay, this is interesting. In simple terms, what does probate actually mean for everyday people like me, and I think a few of the people on the call here today? Can you explain what a probate service would do to help families navigate this situation?
Good morning, everyone. And thank you for the PAC Registrars and Investor Services team for putting together this webinar. It's a pleasure to be on board, as part of the panelists. So going right straight to the question, you said, what does it really mean, for what we understand to a layman by probate services? So first things first, what is probate? We hear probate. What is probate? What do we understand by probate? In simple terms, probate is, the administration of a dead person's assets or estate. Let's call it estate. That's the right word. So it's the administration of a dead person's estate upon the passing of a deceased. So now we'll talk about probate services. This now involves the legal process, the activities involved, that will enable the assets of this deceased person to be transferred or administered in favor of the beneficiaries of the deceased estate. And of course, typically for purpose of context, we're going to be looking at the legal process, involved in these probate services. And for proper context as well, we're going to be focusing on legal state. So now when someone dies and there's need for you to administer the estate of the deceased, typically if there's a will, it's pretty straightforward. You go to the probate registry. Typically, when the will is even prepared in the first place, it should be lodged with the probate registry. So if there's a will, it's easy. You apply to the probate registry, informing them that the person has passed, and then, of course, you undertake the process of applying for a grant of probate. And on the other hand, when the person dies intestate, that means when he dies without writing a will, which in our clime is typical. I think that is more common, because an average African man or even Nigerian man is a bit wary about putting down his will. I remember they were in the firm, we were trying to talk to clients, about wills. They're like, are you praying for me to die? There's a bit of apprehension, with a lot of people wanting to put down their will. So more commonly, among our client here in Nigeria is where people die intestate. So when someone dies intestate, the only way you can administer the person's estate is via a letter of administration. Now that's a process. The process too is you apply to the probate registry. I think maybe Mark should talk about this more, because like I said, this is more common. A lot of us are more familiar with this. So it's a process. You apply, you write a letter of application letter to the probate registry. It can be online. At least thank God, Lagos State now, we're a bit more tech savvy. So you can apply online or you can do physically. So you write a letter of application. Before now, there will be, the family would have decided who are going to be the proposed administrators of the estate. And according to the law, that like a priority of persons, that can apply. Of course, first in consideration and first priority is the spouse of the deceased. Spouse under the Matrimonial Causes Act. In the event there's no, the deceased and the spouse are not married under the act, then the spouse by customary law. Then of course it goes down in order of priority. After the spouse, you consider the children. After the children, you consider the siblings, full siblings of the deceased, or in the absence of full siblings, half siblings of the deceased. From the half siblings of the deceased, it keeps cascading. Look at the parents of the deceased, brothers of the deceased, uncles and aunts, goes that, there's a particular priority. So the proposed administrators, they apply to the probate registry for, indicating their interest to apply for letter of administration. Once they do this, typically there are forms that are given to them for you to fill. Okay, let me even first talk about the application process. When you're applying, there are a series of requirements that are required to, attach your application letter, the name of the deceased, where the property is located, photocopies of his death certificate, and some other requirements. Once you put in your application, you'll be given the forms for filling, for you to provide more details, and then a bank certificate is usually given to you. The essence of the bank certificate for you to take it to the bank, or maybe now pension fund administrators, or even to indicate the assets of the deceased. So normally you take that bank certificate to the bank will stamp on it, indicating what the balance of the deceased is as at the date, you brought those forms to them. So you put those there. If he has shares, you indicate it there. The pension fund administrators, how much was in his account. You go around, just to fill those forms and the bank certificate to give the probate registry proper information regarding the assets of the deceased. Now, where there are situations where, aside from the money in the bank, money with the pension fund administrator, the deceased might have landed assets. Now, with their landed assets, the probate registry has its own team. They will need to go investigate, this asset for purpose of valuation. All this is towards when you have submitted all the necessary documents and requirements. There's supposed to be like an assessment. It's like the estate fees you pay to Lagos state government. Typically, it's 10%. So the purpose of gathering this information is to be able to do a proper assessment. So you come back to the probate registry with your documents, the bank duly filled bank certificates, and all the details of the assets and of the deceased. They carry out an assessment. So based on the assessment, you pay a fee, and then you also pay for publication. The essence of paying for publication is that once the assets are verified, the registry will go ahead and make a publication. The idea is to notify the general public that Mr. A, B, and C, or Mrs. Z, Y, X has come forward to apply for the letter of administration for this person that has been deceased. The idea is to inform the general public in case persons have, objections to you applying for that letter of administration. The Nigerian scenario. Someone may come from somewhere and say, no, so and so person are applying for the letter of administration, maybe as a wife and as the first son. Someone can come from the public and say, no, I am the rightful wife, I'm the first, things like that. So that's the essence of the publication, so that it gives room for the general public to have make an objection, for that letter of administration to be administered in favor of the proposed administrators. So in the event, typically in the event when there's no objection, the probate registry will ask you to provide additional sureties. Typically, 2 sureties are normally asked for, one with a landed asset in Lagos, and of course, they'll ask for other requirements like their IDs, ID cards, and all that, names, contact address, like proper KYC documentation for these sureties. So, like I said, the 2 sureties, one should have a landed asset in Lagos, and then another would provide a statement of accounts for 6 months. So upon submission of these requirements for the sureties, you submit it to the probate registry. They look at it. After, the next process is now they'll call the sureties for an interview, as well as the proposed administrators. Of course, that's the registry is in its own way doing its own KYC on these proposed administrators and the sureties, just to make sure that all information provided are correct, and just to have a sense of their own internal process. Once this is done, it's taken to the probate judge to sign, all documentations, proper verification exercises are done to make sure everything is in place. So once everything is in place and all the payments have been made, you would have to provide evidence of your payment of the estate fees. Once you've done everything, basically, they do their own, the probate registrar signs, and then the letter of course, internal processes, the letter of administration is now ready for collection. So it is that all these activities, even the process of all this, there's a collation, valuation, activities revolving around assets of the deceased is what we refer to as probate services.
Probate
so
services.
typically, yes, probate services. So in the large term, all these activities, the procedures, whether it's by will, by letter of administration, the essence of identifying the assets, valuing the asset, distributing the assets, all these are all probate services. Notification of necessary parties for proper transmission and distribution of the deceased asset to the beneficiaries. All these are what we call probate services.
Probate services. Thank you so much, Mrs. Egbe, for that. And this is it just seems like a long process. Mr. Yinka Adegbola, is there a way to avoid this kind of process completely? Is there a way for us to say, you know what, we can't go through this process step by step, making sure, okay, this is what leads to the other? What would you recommend as a good way to avoid this completely?
Okay. All right. Thank you very much, moderator. Thank you, Igbe, for that intro, and I recognize your worship, Mrs. Taiwa Akone, for being able to join us this afternoon. Your worship, I recognize you. The truth of the matter is either someone dies testate or he dies intestate, like Egbe mentioned. However, because of the complexities in the process of acquisition of probate, whichever way you like it, whether you have died tested or intestate, you still have to go through that process of probacy. It's even worse in the cases of wills, because mostly what you have seen lately is that 80% of the wills are contested. It's either someone wakes up that, look, there are several grounds by which you can contest a will. You can say the deceased is of sound mind. You can say, yes, the paper was not signed in the presence of 2 or 3 persons as required by law. All these complications set in whether someone dies testate or intestate. So globally lately, and what has been done is that people try to go by way of trust, which is more or less like saying that before you die, just put your house together and start managing it ahead of death. What do I mean? Mr. Okoko Michael has properties littered in Lagos, Ibadan, Benin. He appoints a trustees, like a trust firm, and says, okay, yes, trust firm, please manage this asset while I'm alive. It then means there's a distribution ratio for all of it. I mean, it can have like 10% of the proceeds of assets should go to my first child, 20% goes to second child, 30% goes to this. Even he can even use it to plan for his for foundations to raise foundation and endowments, So while he's alive, he's already planning, he's already transferred his assets to a trust. What it then means is that upon his demise, because trust has taken charge of the asset ab initio, even before he dies, it then means that even upon his death, the trust continues. And globally, this is what we have seen that people have used to be able to manage inheritance from generation to generation. I've seen that all over the traveled experience. In fact, I saw something where I am currently. This is an asset of over 100 years, and I understand it's a kind of trust arrangement which has over 3-4 generations. So trust is a viable alternative in order to avoid all these probate and probacy related issues. However, unfortunately, in this part of the world, Africa, they are still we're still scratching it on the surface. So, but I mean, that's all. Let me pause here so that I can allow other of my fellow participants to comment. Thank you.
Thank you so much, Mr. Yinka. I think we'll still circle back to hear a little bit more about how to put your assets in trust and so on and so forth. Mr. Babatunde, we know that probate is essential for securing assets after a loved one's passing, but is the process the same across all probate registries in Nigeria? And what can be done to create a more streamlined system potentially? Because I think Mrs. Egbe also mentioned something about, particularly in Lagos? So what exactly differentiates from state to state in Nigeria? Thank you.
Okay, thank you so much, Feinfolo, and good afternoon to everyone on this call. All right, so the process is not similar across the states in Nigeria. You know, it's a little bit different per state. Like Egbe has rightly mentioned initially, for Lagos State, for instance, Lagos State has digitalized the process to a very large extent, and some other states likewise, like River State. So what it means is that there are some processes that has been cut off, and you know, the faster it has become in some of these states. And equally, there are some requirements. At least there are none of you know, one or two states in the north that requires just one administrator, which is not the case in Lagos State. For instance, if you are to request for a letter of administration or a probate service in Lagos State, the minimum that you are required is two administrators to administer the estates, and a maximum of 4 administrators. But like I said, in some of the states in the north, they allow just one administrator, well, probably because of the value of the assets. Also, equally, like Hegbe mentioned initially, for the you know, administrators likewise, and the requirements, depending on the value of the assets, there are some documentations and some requirements that is required based on the value of the assets. Some may require that you have a landed property as one of the sureties. Must have a landed property if the asset is you know, a large asset, and in some cases you may not require that. You may just require 6 months bank statements for the you know, the sureties likewise. So all in all, the process is not even, but similar in some extent, to some extent, but not across from, you know, one state to the other. And of course, when we're talking about how we can close these gaps, basically, with the help of automation, we can close this gap, and to a very large extent, PAC registrars as well. We're working in conjunction with one of our sister companies within the Pan-Africa Capital Holding in order to help you know, some of these states to digitalize and ensure that all this process, you know, is seamless across the various states within the country. Thank you.
Interesting. Thank you so much. I mean, digital is definitely the future, and it's expanding a lot. So I'm very interested to see how we can implement those systems in Nigeria so that we can have streamlined processes across the board. Thank you so much for that, Mr. Babatunde. So I will extend this question to Mrs. Taiwo. Can we handle things like dealing with banks directly without going through the probate process? What are the pros and cons of keeping probate?
Can you repeat that question? That question was not clear. Can you
No
repeat
problem,
the question? Yes.
No problem, ma. I was asking, good afternoon, man. I was asking that,
Yes.
can we handle things like dealing with banks directly without going through the probate process? And what are the pros and cons of keeping probates?
Good afternoon. I appreciate the invitation from the organizer of this program. I always see it as a means of getting a feedback from persons and users of our services at the probate registry each time we are invited for this kind of program. Thank you very much for the invitation. Now, the question as to whether money in the bank can be dealt with by beneficiaries or loved ones left behind by a deceased person. I will say by the banking laws, no bank will release any money to any beneficiaries or loved ones when the deceased person has died. You still have to go through the process of probate. There was a time they were abandoning the issue of PO, what that we open an account, and then the person we instruct the bank that after the death of the person, then the money can be returned back to him. But I don't know if there's any law that back up that kind of process. But for our law in Nigeria, banking law, if there's any money left in the account of the deceased person, the person has to go to the probate registry to get a letters of administration if there is no will. But where there is a will, he must have addressed it in his will as to how it's going to be shared. And even if it is addressed in the will, you can't still have access to that money except to get a probate grant or letters of administration. That is when you can have access to that money. So that's my answer to the first part of the question that you had. As to the pros and cons, yes, I think that was the second question.
Yes.
The second question was,
yes, ma'am.
As to
skipping probate entirely. Skipping the probate process entirely.
Keeping the
yes, ma'am. I said the pros and cons of skipping the probate process.
Well, I don't really understand that question, really, but the pros and cons of having a probate process is that it will give you the opportunity to access what the deceased person has left. For example, it could be money in the bank, it could be pension, it could be other benefits that the deceased is entitled to, maybe in his place of work. It could be real properties that he left behind, such that if you want to deal with them, for example, if you have tenants in a property, they will tell you they don't know you. What gives you the power? Because it's not your name that is on the title document. You are not the one that put us in possession. What gives you the power to come and be administering the estate? They will ask you for that document that gives you that power. And it is only probate that you can get to be able to show that this is what gives you the power. If there is no will. But if there is will, the deceased person would have addressed it in his will that this is the person that is entitled to it. And you will still need a probate grant to be able to deal, because that is what you are going to tender before the court to show that you have been appointed as an executor. You have been given the power to administer, because the wills give you the power. The wills give you the power to be able to deal with the property. But for you to administer properly, a probate grant must be given. And then another pros of having a probate grant is this: if you are not ordinarily, if the deceased person has prepared a will, it's possible that your name may not be one of the executors to be able to administer. But where there is no will and the deceased died, I want to have access to it, of course, those that are close to him first will come in order of priority, like Mrs. Egbe has said, the surviving spouse first, and then the others that come after. So for you to be able to administer properly, you still need to come and apply for probate, so that will give you the power to administer the estate.
Thank you so much, Ma. Mr. Babatunde, do you have anything to add to what Mrs. Taiwa cons of keeping the probate process?
Okay, thank you for that. She has rightly, said it all. Basically, I would only add by saying that there can never be any advantage of skipping the probate process. Because you have to follow the due process, the legal way, of administering the assets of a deceased person. So it is a process that you must follow to avoid issues of impersonation, and so on and so forth. So basically, there can never be any advantage of skipping the probate process. It's a process that you must follow, just as she has mentioned, in the case whereby the person dies, intestate. Thank you.
Thank you so much, Mr. Babatunde. So still on Mr. Babatunde, I'm curious. So we've been hearing the letter of administration. So once we have secured that, what are the next steps or the next key steps involved in managing the estate efficiently?
Thank you so much, Feinfolua. All right, so I'll just answer that question by citing an example. I remember in the past when registrars and organizations used to, dispatch dividend warrants and share certificates. So it's just basically a shareholder or an investor that has a share certificate or a dividend warrant in his or her custody. It amounts to nothing if you have not followed the process of either taking the dividend warrant to the bank to lodge it inside your bank account, or similarly, the share certificates, you give it to your stockbroker in order to dematerialize and lodge it with CSCS, your account with CSCS. So the same process, if you have been issued a letters of administration, is not for you to keep in your house or in the bank accounts or in a safe place. It is required for you to take it to the places where the deceased have assets. Financial institutions. It could be registrars where the deceased have assets, or pension fund administrators, or bank. Basically, so you are expected to take the letters of administration to these places, and equally, they are expected likewise to reconfirm that the letters of administration that you have brought is genuine. There's a process called reconfirmation, by it is still sent back to the probate registry where it was issued, maybe Lagos or or your states or states or Port Harcourt. So they are expected to confirm that yes, this letters of administration is genuine, and in that process, for registrar, for instance, there's something we call transmission. So in that process, the assets, the shares is being transmitted from the accounts of the deceased to an estate account. So it also involves that you open an estate account, the administrators that the probate registry has been approved to administer the estates. They open an estate account in order to administer the assets of the deceased. So basically, what is expected after the letters of administration is issued or collected is for the administrators to take it to all these various places and ensure that the asset is transferred to the estate's accounts for administration. Thank you.
Awesome. Thank you so much, Mr. Babatunde, for that. I think redirecting the conversation to Mrs. Egbe, I'm curious as to, so let's say that someone they believe they've been named executor of a will or in a will. What are the key steps they should take to ensure that their loved ones' wishes are honored and that the transition is as smooth as possible? And I think I'll go a step further to even go and ask, like, what if you don't even want to be an executor at all? What if you feel like, okay, this is such a big responsibility, I don't want to do this? How can they manage this process? Can they reject being the executor? How would they transfer that title to another person? So over to you, ma'am.
Okay, thank you so much. So first things first, the first question is if someone suspects he's an executor. So basically, like I said, typically when there's a will, it's usually lodged at the probate registry. So in such an instance where you suspect you're an executor, maybe the testator didn't tell you you'll be an executor, during his lifetime. So the first is to apply for a search. There's a way you can apply for a search at the probate registry just to find out whether, there was actually a will. And when you do that search, and of course, if the will has been lodged with the probate registry, the search will come out to say there was a will. So upon due process, you inform the solicitors or family representatives, you inform the probate registry that the testator has passed, and so there's need to administer his estate. So of course, it's similar to you apply for like your worship said you have to apply for a grant of probate. So you, for that process, so once the will is gotten, okay, let me go through the process. You apply for a search. Once the will is found, there's going to be like a will reading. The idea is that because typically when the will is prepared, it's sealed. The essence of it, that's part of the requirements. Mr. Yinka spoke about some of the, requirement, the requirements for a valid will, which he was talking about, such as signing, witnesses to attest that the testator was of a sound mind and capable of, he knew what he was doing when he was writing the will, to ensure that there was no form of duress or, So part of it is the will has to be sealed. It shows that, it hasn't been tampered with. So once you find the will, the probate registry invites members of the family of representatives for like a will reading. So during the will reading, you break the seal before everyone to kind of authenticate, to a sense of credibility, to authenticate that the will is original and hasn't been tampered with. So you read the content of the will, and in the instance, like you said, the person is assuming he's thinking he's an executor. The will normally tell you who the executors of the estate are. So if you're an executor, it will be stated. Sorry, can anyone hear me?
Yes, please, Sege. You can go ahead.
I think there was a technical glitch. Sorry, maybe from my end. Okay, so as I was saying, so you apply for the grant of a probate, get the details of the assets of the bank-wise, and then of course the will typically tells you how the assets, the testator would have straightened his will. I want this to go to this person, this house to, typically you do all that. So once you get necessary requirements and submit to the probate registry, there's called something like a will marking. So the will marking is more or less executors coming to say and attesting to say that they will abide by the dictates of the will, in accordance with the law. So once that will marking is done, assessment, the necessary fees are paid at the probate registry. The same internal process ongoing to get the grant of a probate. And once the grant is gotten, like your worship said, that is what gives you the authority, the power to be able to administer the estate of that loved one. Now, the second part of the question says, there may be times you may be appointed as an executor, but for whatever reason, you don't want to function in that capacity. It may be because you're not feeling, maybe you feel mentally you're not up to it, you're not feeling well, you may be out of jurisdiction. For whatever reason that's really happened, you don't want to be an executor of a will. Yes, you can. So in that instance, what you will do, you call it a renunciation. So you renounce. Can you hear me? Can you see me?
Yes, please, we can.
Okay, so in that instance, you renounce it's more like you prepare the necessary papers, like you file it before the court, stating that you don't want to act as an executor, and giving reasons why you cannot act in that capacity. So yes, it's possible to say you, for whatever reason, that you don't want to act in that capacity. So of course, when normally there are more than one executors, there's always a minimum of 2 executors. So in the instance of you don't want to act in that capacity, your responsibility will most likely be transferred to other executors of the will, or in the event that maybe you are just 2 and you stepping aside, we leave just 1, you have to undergo the process of appointing like a replacement. Family, of course, this is in collusion with the family representative and loved ones. You find like a replacement, to take over the responsibilities you would have executed as an executor of a will. Thank you. Hello.
Okay, thank you, Egbe. Thank you for that exposition. So I would like to direct, there's some questions on the chat box. I would like to direct to Her Worship, Mrs. Taiwo Akoni. What is the difference between a letter of administration from magistrate court and that obtained from the High Court?
Thank you very much. There is no letter of administration issued from the magistrate court because the magistrate court does not have a jurisdiction to issue letters of administration. In fact, they have no jurisdiction to deal with anything that's got to do with probate. Probates are usually handled by the High Court. It's a department of the High Court. It's for, like in Lagos State, it's part of the Family and Probate Division of the High Court. So the magistrate court has nothing to do with issue of probate at all. The only, I'm sure the questionnaire is confused because they said I'm a magistrate. What I just do there is to see how the place is being organized and run. I'm just the HOD of that department. But like I said, it is the High Court that deals with issue of probate matter, not magistrate court. So there's no letters of administration issued from magistrate court at all.
Okay, so my back to you before I leave it to the moderator. What's the average time for the probate process, to be concluded? Because I mean, we know how frustrating this could be sometimes.
For probate process, for the time line, for the time period, it depends on the jurisdiction. Like in Lagos State, we all understand that there are a lot of applications in Lagos State. There are a lot of applications in Lagos, and you cannot compare it to other jurisdictions. You can't compare it to jurisdictions like Oyo State, Ogun State. But I would say that sometimes it depends on the kind of assets that are included in the application. Because if you're applying for letters of administration that will cover real property, the time lag will be a bit longer because of the route it's going to take. Before we go through the probate judge, it will go through the valuation unit, from valuation unit to the probate judge, and then to the honorable chief judge for approval of the valuation that has come up. But if it is just money in the bank, shares, benefits, and all that, the time frame is usually a bit slower. But I would say, on the average, we are looking at between 4 and 6 months, taking into consideration any other issues that may arise. What are those issues? Sometimes when applicants collect their bank certificate, it takes them time to come and return the bank certificate for assessment, for payment of estate fees. Not only that, sometimes when we ask them to bring their shorties, it takes them time. You say they're still looking for shorties. And these are the requirements of the law that must be complied with. Sometimes it could be that if there's a kind of rift between the family, would also delay the process. And then it's also going to go through publication, which takes like 21 days. waiting for the possibility of any objection being raised from any parties. But like we have tried to deal with some files, and we found out that it's possible for an early to be ready within 4 months. 4 months on the average, depending on the cooperation of the applicants, like I said earlier on. Sometimes some of them cannot even pay the estate fees. So we have to write to the bank. Before the reply comes, they will come and confirm whether it's the letter emanates from us. All these processes, they take time. So that can kind of slow you down. So we are looking at the average of 4 months, depending on
average
the,
4 to 6
Excellent.
months.
Excellent.
That is so interesting. And I like that you bring up the aspect of fees and taxes, Mrs. Atayo. So I'm curious, can you explain how these fees are calculated and what options are available if someone can't afford the upfront costs? And what can they even access funds from the deceased accounts? So these are just a few of our questions.
Probate fee is also, we also call it tax, and it's also referred to as estate fee. The payment of estate fee in probate is usually 10% of the total assets of all the collation of the disease assets like money in the bank, benefits, the real properties included. But where there's real property included, there is a way we do the calculation. Now, we don't use market value to get the tax for real property. What we use is fair market value. So if, for example, the market value of a property in Ikoyi is 100 million, the fair market value from our own assessment may be like 50 million. And when we get that 50 million, we work out 35% from that 50 million. Whatever is gotten from that 35%, from that 50 million, we work out 10% of it, and that will stand as the estate fees, which goes to the government. But like I said, if there are money in the bank, money like shares and also shares. Okay, for shares, it's usually 2 naira per shares. If there are no real property in the application, but where there is real property in the application, it is 1 naira per share. That's the way we calculate it. So when we collect everything together, the 10% of the money in the bank, shares, and what has been worked out from a real property is what we charge as the estate fees. Pension is not taxable. We don't tax pension. But in Lagos State, what we do is this. The rules provide, and the forms that are provided also provide that applicants should disclose their personal charters, which is taxable. When we're talking about personal charters, we're talking about like television, cars, and all that. Mostly applicants that are applying for pensions, they don't usually disclose the personal charters. So because they don't disclose, we have worked out 0.5% of whatever that pension is. So if you work out 0.05% of the pension, whatever we get from that 0.05%, we now get 10% out of it, which is very minimal. Very minimal. So that's how our estate fees goes. That's how we work out our estate fee. But where an applicant cannot pay, some can pay, maybe they can pay by installment. If it is not possible that they can pay by installment, they can write to instruct the probate registrar in accordance with the provision of Section 7 that provides that the Honorable Chief Judge of Lagos State should be the administrator of the estate within the period of the deceased death and when the letters of administration is being granted. So within this period, we use that section to write to the bank based on the instruction of the applicants that we write on their behalf, that they should deduct the estate fees from the balance accruable in the account of the deceased person. And that's how we can assist them to pay the money. Or in the alternative, they pay by installment. Well, like I said, sometimes this procedure kind of is this slow.
This is so interesting.
The bank become and confirm. In fact, some banks don't want to even admit our application, because we had some experience like that. That you write them and they won't even respond. But I always say it's a contempt of court, because it's an order of court. Whatever the registry is doing, we are doing it on behalf of the Honorable Chief Judge, and they've got to just comply. So that's the position.
Thank you so much, Ma. So I think we've also been talking ad nauseum about the letter of administration. So in a situation where maybe that has been filed or been given earlier, maybe a few years back now, in what situation, and they are facing hefty defaults fees, that can be very discouraging of the VAT, even with just maybe they are running away, this and that, I don't understand this process, I don't understand this process. So can you explain what these defaults mean? Why are they experiencing these defaults? If they need to amend something in the letters of administration, and what options might be available to actually resolve this situation?
Well, there is a saying, where there is no law, there is no sin. There's also a saying, ignorance of the law is not an excuse. The provision for statement of account to be filed is there provided in our rules of court, specifically in the present rules of court of 2019 of the High Court of Lagos State Civil Procedure Rules, Order 61 Rule 16. It provides that administrators and executors that have been appointed are required to file their statement of accounts of the administration annually. And when they fail to do so, they have to pay the default fee of 100,000. But prior to 2019, that is from 2012, before 2012, the rules was that the courts will make the order that a statement of account of the administration of the executors or administration should be provided for in the court. But from the rules of 2012, it specifically provided that statement of account must be filed annually. And where it is not filed, they will pay a default fee of 200 naira per day. That was prior to 2019 rules, yes. But from 2019, it is 100,000 naira flat.
So is there an amount of years? Like, okay, 10 years below 100,000 naira flat? Or
for example, if you are giving your letters of administration today, say you are giving May 30. Let's start counting from 30. It will not start counting until the May of 2025 before you submit your statement of accounts. If you obtain your letters, the grant of probate today, or your grant of letters of administration, it is taken that you start the administration of the estate immediately. But we don't start immediately. It's the following year that you are going to submit your statement of account of how you administer the estate. So the purpose of asking for it is for the benefit of the beneficiaries. Yes, so that they can account for the administrations of the estate. But you see, asking for these default fees is also excusable if they can show with concrete evidence, and convincing one for that matter, that there had not been administration of that estate within that period, because it's possible that maybe after the letters of administration was granted, one of the administrators died. And the law provides, especially section 21 of the administration of estate law, provides that there must be at least two administrators, not less than two administrators, and not more than 4 administrators. So if one of the administrators is missing, of course, you know that administering that estate, so it can be excused that between the period of the death of one of the administrators, administration of the estate cannot be accounted for. So on that basis, it can be excused. And we also look at it from this point of view. We remove weekends, remove NSAS period, especially those that have collected their LA within that period. NSAS, weekends, COVID period, we remove all those. So it kind of reduces. Yes.
Reduces that as well. Thank you so much, ma'am. We've learned so much today, and we have a few other audience questions before we actually bring the session to a close. So I think we have time to take just about 2 questions that are directed to your lordship. So, Ma, so someone is asking, I think 4 months too long in this modern age for the process to elapse, the time frame that has been for this entire process to be accounted for. What are your thoughts on that, Ma? Is it 4 months too long?
Well, I will say that it's not too long if due process has to be done. We've seen a situation where they get it so early, and then there was an incident that happened in Abuja that the administrator applied for letters of administration for somebody that is still living, for a living being. So if due diligence are not done, you can give letters of administration to a wrong person. I'm telling you, because we know what we see every day there. We've seen a situation where it is the tenants that were living with the deceased person that came to come and do letters of administration. Are they eligible? They are not eligible. But because of the due diligence that we are doing, we are able to filter out all these anomalies. But if you don't do that, then you do it wishy-washy, and then because you want to have access to it, the wrong people will be
due diligence is really the name of the game here. To be able to make sure that all bases are covered. It's important that however long it takes, it should take that long. Yes, ma'am.
Look at the issue of publication. If you put it in the as a notice to the world, if you have an objection, come and file. If a publication is not done, how will they be able to know that there is an application going on? Even in that instance, some people will still come behind to want to go and file elsewhere. So I don't think 4 months is too long, because I've tried to compare with even other clients. They don't rush things too. They don't rush things, because I've had people are coming from abroad to come and do this application, and when they got the order, I know how long it took them before they get it done in England. So I was telling them that we were on our neck here now, but in England you couldn't get it as fast as that.
You couldn't get it as quickly as that.
Yes. So
yes, ma'am. I have another question here. Can property in another state be covered by probate obtained in Lagos? And this is from one of our participants. No.
If there's a letter of administration granted in Lagos, we only cover properties in Lagos. The one granted in England, we cover the one in England. But where you have that letters of administration or probate grant, whatever it is, you can come to Lagos where the deceased has a property with the certified true copies of the grant that you collected from those states, from another state. Then you apply for resealing. So what we do for you in Lagos will be a resealing for you to be able to administer those properties that are within the jurisdiction of our probate registry.
That's so interesting. Thank you so much, ma'am. So I want to take one more question from here. So someone is asking where the value of a proposed estate is estimated to be about 50,000 naira. What are the available probate processing options for such a small amount?
If the property is valued as 50,000 naira,
yes, the estate itself.
We have small estates, administration of estate law, small estates in Lagos State. So where the value of the estate is less than 100,000, we don't allow the processes to be as cumbersome as it is in a large estate. Because in the first place, we don't do publication in the newspaper. We do our publication within, which is just within 14 days. And then the cost is also less.
Yeah.
I think it's just a normal fee of like 1,500 or thereabouts. So it's not much. But we are at the verge of increasing it upward. The bill is still in the house, so I pray that they pass it on time. We are looking at increasing it to 1.5 million or thereabouts.
Interesting. So thank you so much for being here with us, for imparting us with your wisdom, with your knowledge, for being like a mom to all of us here, just letting us know, okay, this and this is how you should go about the probate process. This is why it's important. Due diligence is important. The fees that you're paying are important to be able to help the process move along smoothly. I really appreciate that there are even provisions for those that are not able to afford the fees upfront, the instrumental payments, the maybe the court trying to help. Okay, you can get the money from the estates that were even trying to sort this probate issue over. So thank you so much. I wanted to actually direct a final questions, and I'll just throw it out to anyone who is interested. Mrs. Akoni has actually been saying so much. So anyone who's interested, it will be that how long, okay, no, let me see. Digitalization of the process across the states can curb this, because we still get a lot of impersonation, fraud, despite the due process. So does anybody have any thoughts on this statement from one of our participants, that digitalization is so important and is key to making sure that we can curb a lot of the fraudulent and impersonation that even Mrs. Akoni highlighted about? Someone just saying, oh, I presented a letter of administration, we're seeking one, and the person is still full and well alive. Does any of our panelists think that digitalization is actually the way to go? Anyone? Well, should I ask someone directly? Okay, yes, Mrs. Taiwo.
Okay. Digitalization is the in thing. And what we have discovered in Lagos State is this. Prior to digitalization of our process, they can apply in Ikeja, and then there's a query or a caveat that we filed. They will now go to Lagos to go and start another process. But because of the digitalization now, that is impossible. Because as soon as they put that name of the system in Lagos, if there's a trial application in Ikeja, as soon as they put that name on the system in Lagos, it will pop up. It will pump up on the system that there is an application in respect of that estate. So these are the wonders of digitalization, and then it's also slow the process. It will also it also fasten the process, because now we have a situation where you can walk in today into our registry. You can fill all your information online. And then collect your birth certificate that very day. And then
that is always so awesome for people like people like me that like
so before.
Digital processes, yes.
Before they will take it home, use how many months to fill it and all that. That is no longer the position. Now, once you have all your documents, all the requirements, you just upload them, then give you the bank certificate. Then you can go and try accessing the assets. So these are the wonders of digitalization. And then if it's duplicated in other states, and
definitely
then maybe
there's a streamlining happening.
Then there's a kind of a joint working with the other states. If there's an application here in Lagos State, they can also see it.
It can also reflect. Yes. That is the power of the digital world that we are in now. Thank you so much, Ma. So I know that there are a lot more questions, but we actually have our time is far spent already. So you can actually send all questions to info@pacregistrars.com. We'll be submitting that in the chat shortly. So you can just copy and paste. Remember that this is the first of a series. So if you enjoyed the conversations today, please drop your favorite emoji in the chat. Let's know. Let's meet ourselves. I can't wait to have everyone here on the call again for subsequent series. I think we had such an amazing time with one another today with our lovely, awesome, insightful panelists. Thank you so much, Your Lordship, Chief Magistrate Taiwo Akoni. We appreciate you donning us with your presence. A huge shout out to Mr. Yinka Adegbola, MD PAC Trustees, and to the MD PAC Registrars and Investors Limited, Mr. Ifeanyi John. It has been an awesome, awesome time with everyone here today. Mrs. Egwe Osikena, Mr. Babatunde Oyeniyin, your knowledge, your insight has been so helpful today, and I can't wait for subsequent series. I know we've learned so much today. Please remember, any other questions they are like, I actually need this question now, I need an answer to this now. Please feel free to send an email to info@pacregistrars.com. Someone will definitely collate all the questions and provide responses and share to everyone who has asked. So thank you so much. Any final words from the PAC Registrars and Investor Services Limited team? Any final statements, final words?
Okay, once again, thank you, Faye Follower. Thank you for taking this call. Thank you once again, Mrs. Taiwo. We are so grateful to have you here. Thank you for the wealth of knowledge that you've passed across to us, all our panelists, and to the one I call Egmo, Mr. Yinka, thank you so very much for your time. Company Secretary, thank you so much. Babatunde, thank you so very much. I thank every one of you and all our audience, our guests that have logged into this program. I believe that you've learned so much today. Don't hesitate to call on me, to call on any of us. We are here to ensure that your probate process is made seamless for you. Once again, I wish you all the best of the day. Thank you.
Thank you so much, sir. Thank you so much, everyone. Please make sure that you tune in for our next session. So I think details about that will be coming in as soon as possible, of course. So thank you so much for our panelists once again. Please do have a lovely, lovely Wednesday ahead and a beautiful rest of the week. Bye, everyone.
Bye. Thank you so much, everyone.
Thank you.
Thank you so much.
Thank you.
Right, yeah. Restroom.